Hi, everyone. Thanks for joining us. My name is Greg. I'm with the San Francisco Office of Labor Standards Enforcement. Thanks so much for joining us for today's webinar, which is on the Formula Retail Employee Rights Ordinances, or we like to call it FRERO. Before we begin the actual content, I just want to cover a couple housekeeping items. First, to let you know that there haven't been any amendments to the law. There's no new rules or administrative guidance that we've put forward, but we thought it would be good to do a refresher on the laws. It's been a couple years since it passed. See if you have any questions or feedback for us. So again, thank you for joining us today. Do also want to let you know that we're excited. This is new for us as well, that we have a couple of community partners who are working with us on outreach and education on the law, and will be helping us today. So I want to go and talk about our presenters. So I'm happy to have Lucia Lin from Young Workers United, as well as Esperanza Fonseca from United for Respect. Today, Lucia is going to be the lead along with me, and Esperanza is helping us in the background. So many thanks to both of them for joining us today. Also want to say that at the end of the presentation, there's a slide with contact information for my office as well as for these two organizations. So if you have questions that come up after the webinar or at any time, please feel free to contact us. And I'm also excited these groups are available for trainings for your staff or managers. So just to make sure that everyone is aware of their obligations under the law. A couple more housekeeping items before we dig into the content. You should have this screen if you haven't done GoToWebinar before. Just want to make sure that you understand the control panel a little bit. One thing that's helpful is the orange button up there, the arrow. So what I found for me is that my ability to see the slide is sometimes reduced by the control panel. So if you hit that arrow, it'll minimize it. And then if you hit it again, it'll open it back up for you. And then there's the questions box. So at any point during the webinar, send us questions. And at the end of the webinar, we're going to go through the questions and answer as many as we can. If we don't answer a question, it's because either we've run out of time or it's very sort of specific question that may not be applicable to the general audience, or it may be one that we need to do a little more research on. So at the end of the webinar, we'll get a list of everyone who participated, and if you had a question, it'll show us who asked the question. So if we don't answer your question during the webinar, we will follow up with you directly. Also, another question we get is, will we be sending out the slides? Yes, we will. We'll be also posting this to our website. So recording of the webinar will go to our website. So as I mentioned previously, the OLSC's contact information will be in a slide at the end of this. And I want to just go over to here. So when you go to the web address that's on that slide, this is the page it'll take you to. It's our web page devoted to FRERO. And each of our laws that we oversee, we have a web page devoted to it. So this will give you more information. It gives you the poster. You can link to the law itself, to our rules that we promulgated. That's all here on our web page. And then the webinar is going to be posted if you go to the About OLSC header and then go down to Trainings and Webinars. Then if you scroll down, you'll see we have, I'm going to leave it here, monthly webinars on our healthcare security ordinance law along with the Department of Public Health. And then we have our past webinars over here. So we'll post this one as soon as it's done on this web page. And then you can see there's also other laws if you're interested in those as well, be it paid parental leave or lactation in the workplace, healthcare security ordinance. Those webinars are posted on this web page on our website as well. So that does it for the housekeeping. At this point, what I want to do is turn it over I want to turn it over to Lucia, so I'm going to change presenter. All right, Lucia, take it away.
All right, thank you. Thank you, Greg, for the introduction. Does the screen show up? I think it's working, right?
Yep.
Great, awesome. Thank you so much for the introduction. My name is Lucia Lin. I'm here from Young Workers United, and I'm excited to be able to give this presentation about the Formula Retail Employee Rights Ordinance and some of the going through a refresher on what the ordinances look like. So we're gonna start, I guess just to back up really quickly. So our agenda for today, we're gonna go over the Formula Retail Employee Rights Ordinance, do an overview of the entire ordinance, review a small case study, a little bit of research that was done on the gap in regards to scheduling and scheduling issues for employees. We're going to go over some scenarios of common challenges that have been experienced in San Francisco around the ordinance itself. And then, as Greg had mentioned, we will end with follow-up resources and a chance for questions and answers in which people can put that within the in the questions box of the GoToWebinar control as they come up. So we'll get started first with the overview. So to begin, just wanted to give a little history about the ordinance, the purpose, and where we are at with it in San Francisco. It was adopted by the San Francisco Board of Supervisors in November 2014, and the requirements took full effect in October of 2015. San Francisco has been a leader in establishing fair labor standards for communities through protections such as the minimum wage, the paid sick leave, healthcare security ordinance, and now the Formula Retail Employee Rights Ordinance. This ordinance covers 40,000 retail, restaurant, and service workers to ensure that workers have access to fair, predictable schedules and to discourage abusive on-call scheduling practices. This means that San Francisco eligible employees do not have to put their lives on hold while arranging their work schedules, and that more stable work schedules that are predictable, stable, and flexible can also help employers to align business operational objectives with labor costs. So to begin with, when we're talking about the Formula Retail Employee Rights Ordinance, it only covers certain types of employers within San Francisco City and County. As you can see on the slide at the beginning, the definition of covered employers is defined by the Planning Code, which defines what a Formula Retail establishment is. And Formula Retail Employee Rights Ordinance covered employers are Formula Retail establishments with the definition above, who have 40 or more locations worldwide and 20 or more employees in San Francisco. Janitorial and security services contractors of covered employees under the ordinance are also covered by most of the provisions within the ordinance. In its contracts with these businesses, Formula Retail Employee Rights Ordinance covered employers must include a provision requiring the contractor to comply with these laws, as well as a copy of these laws. So we'll go into the actual what the ordinance covers, beginning with additional work for part-time employees. So before hiring new employees or using contractors or staffing agencies, FRERO covered employees shall first offer the additional work to existing part-time employees if the part-time employees are qualified to do the work, and the additional work is the same or similar to work performed by part-time employees. The offer must be in writing or posted, and employers are only required to offer hours up to 35 hours a week. Within the rules and the FAQs, there's also more details about how additional work may or may not be offered for part-time employees under the ordinance. Next, we have employee retention. So if a formula retail establishment is sold that's eligible under the ordinance, the successor employer must comply with the following 3 provisions. They must continue to employ eligible employees for 90 days, and this does not apply to managers or supervisors. Secondly, they must continue to employ eligible employees during this period under the same terms of employment. And thirdly, they must retain employees by seniority if fewer employees are needed. Next, I'm going to go into the advance notice of work schedule, or as it's commonly known, 2 weeks notice. This is one of the bigger and more commonly applied parts of the ordinance for many businesses that are covered under FRERO. So under advance notice of work schedules, employers must provide new employees with a written estimate of the employee's expected shifts per month and the days and the hours of those shifts. Employers must consider a new employee's request to modify the expected work schedule. And finally, employers must provide employees with at least 2 weeks notice of their work schedule by posting or transmitting electronically. Next, we're going to go over predictability and on-call pay. So in the case in which an eligible employer needs to make schedule changes for an employee in the process of their business, they must provide predictability pay, which is compensation above an employee's regular pay for each change in schedule. The table on the slide indicates what the compensation would look like. So as you can see, if there is less than 7 days notice and 24 hours or more notice for any length schedule shift, an employer is required to compensate predictability pay for 1 hour of pay for that employee. If there is less than 24 hours advance notice and the shift is 4 hours or less, the compensation required is 2 hours of pay. And if there's 24 hours, less than 24 hours notice and more than 4 hours length of a shift, then it would be 4 hours of pay. Employers must compensate an employee for each on-call shift in which the employee is required to be available but is not called in. So if there is an on-call shift for a business that is 4 hours or less, and the employee was required to be available but was then not called in for that particular shift, they are owed 2 hours of pay compensation for that time. And if that shift length was more than 4 hours, it would be 4 hours of pay. The next slide is going to go over some of the exceptions to the cases around predictability and on-call pay. So no predictability or on-call pay is required in the following cases: threats to employees or property safety, public utilities failures, the business operations couldn't begin or continue due to an act of God or other cause not within the employer's control. Another previously scheduled employee cannot work and the employer did not receive 7 days notice of the absence. Another previously scheduled employee failed to report to work, was terminated, or was sent home for disciplinary action. An employer requires an employee to work mandatory overtime. And finally, that the employee request change in shifts, hours, or work schedule. The next provision that we're going to go over is equal treatment for part-time employees. So for part-time employees that are starting starting hourly wage, they have the same starting hourly wage as full-time employees who hold jobs that require equal skill, effort, and responsibility. Part-time employees would have the same access to paid and unpaid time as full-time employees in the same job classification. The time off hours may be prorated, and that they would be eligible for the same promotions afforded to full-time employees. Finally, the additional employer responsibilities within the ordinance. There's a multilingual notice that is in the slide as well as on the website that Greg had showed earlier. You can download and print the notice. It's required to be posted to inform employees of their rights. And retaliation is prohibited. It is illegal for an employer to take adverse action against any person in retaliation for exercising their rights under these ordinances. And in terms of investigation and enforcement, the San Francisco Office of Labor Standards Enforcement, whom we call OLSC. OLSC is authorized to investigate and enforce violations of the Formula Retail Employee Rights Ordinances. This may include payment of lost wages, payment of penalties to the employees and to the city, $500 in administrative fines, and the city attorney may also file civil action if there are violations of the ordinance. So next, we're going to go over a case study of the gap, and this case study will also be, I believe, available and posted after the completion of the webinar. So this case study was in 2015. GAP partnered with leading academic researchers on a randomized experiment to test a multi-component intervention designed to provide store employees with more stable schedules. Researchers from the University of Chicago, University of California, and University of North Carolina sought to test if retailers could improve work hours for frontline sales associates and enhance profits. These are some of the major findings from that study. So first, that stable schedules significantly boosted profits. In the 19 GAP stores that provided stable schedules, they earned an additional $2.9 million in revenue over an 8-month period and increased sales by an average of 7%. For comparison, retailers often aim at a 1 to 2% sale growth in a given year. The stable schedules were able to double labor productivity. Labor productivity increased by 5% in GAP over the study time. Stores that implemented stable scheduling by 5% in the Gap stores that implemented stable scheduling. This productivity increase is double the average annual growth in overall retail labor productivity from 1987 to 2014. Stable schedules were able to improve retention of seasoned sales associates. The Gap workers with the longest tenure and most experience received a more stable income with a soft guarantee of 20 hours or more per week. This intervention improved retention rates amongst those senior high productivity workers. And finally, decisions from corporate headquarters, not customer traffic, drive most schedule instability was another finding. What they found that while companies had often argued that fluctuation in customer demand drove unstable schedules, researchers found that fluctuations in store traffic accounted for only 30% of the instability in payroll hours. Most of the schedule instability, especially from last-minute schedule changes, came from factors within corporate control, such as last-minute changes to store promotions and inaccurate inventory. So finally, we're going to go into scenarios of common challenges with the Formula Retail Employee Rights Ordinance in San Francisco. So these are some common scenarios. The first is that challenges that employers may have with complying with the ordinance. The first is that posted schedules do not indicate a run date that indicates a 2-week advance notice. So in order to have proper documentation that a covered and eligible employer is providing 2 weeks notice to its employees, it needs to be able to be indicated. The second is that no documentation that additional hours were offered to part-time workers before hiring new employees. And the third is not having iterations of employee schedules or documentation on why schedules were changed. As you can see so far, there are a number of detailed requirements on schedule changes, and in order to understand compliance, that those types of changes need to be well documented within a covered employer's business. And follow-up resources. So if you have any questions that aren't going to be answered as I wrap up this presentation, you can, of course, visit the San Francisco Office of Labor Standards Enforcement, OLISI website, which is listed here, as well as a number. You may also visit Young Workers United or United for Respect for any further questions. So with that, I'm going to open it up for questions or clarifications from the audience.
Great. So thank you, Lucia. So just to remind folks, you can ask questions through that control panel on the right in the questions. So we've got a couple. Let me jump into the first one. And Lucia, I'm going to take the controls back a little bit because I want to answer this one by showing our website real quick. So the question is, do you think this law applies to retail banks with walk-in banking centers? And so right now I'm looking at our FRERO website, and you'll notice the first link in the first paragraph is that the law applies to formula retail establishments. So if I click on that, that definition of formula retail establishment is actually in the planning code. So what you want to look at and what we would look at is if it's in the planning code. And this is a good web page, again, linked from our site that you can use. And so on the right side, I'll put my arrow on it, you can see that financial services, or here's the service financial, is a category of formula retail. So that would cover banks. And if you have any questions about what is and is not a formula retail establishment, you can, again, go from the link on our webpage to the planning department's webpage, or you can call the planning department directly, which is what we would do as well if we had a question about that. So that's the first question. All right, let me see some of the other questions. Okay, not totally understand. So if we're not sure the question, we will follow up with you to get clarity and make sure. Okay, so here's a question, which is, sorry. We provide 7 days or more notice regarding schedule changes. Does this mean that predictability pay is not required? The answer is yes. So that starts to take effect at 7 days or less is when the predictability pay provisions start to kick in. Do remember that you are required to post an initial version of the schedule 2 weeks in advance, but the actual penalty for changes to that schedule kick in beginning at 7 days. Let's see, how does enforcement of FRERO compare to other labor law standards? Have there been many complaints or settlements? Does OLSC maintain a public record of enforcement actions? So we have about 11, actually I'm going to say now 8 or 9 active cases, and we have 3 settlements thus far. And what we do is subject to public record, yes. So people can make public records requests of our office. We will never give out names of complainants, but other information once the case is closed is for public record. Will the recording be posted to the OLSC website or only the slides? When will it be available? So yes, it will be posted. It's on our, I'm going to scroll up and show again. If you go to our webpage in the About OLSC header and you go down to Trainings and Webinars, if you scroll down from there, you'll see our HCSO webinars, which are monthly, and then past OLSC webinars. So we're going to post this webinar to this webpage in that section called Past OLSC Webinars, and hopefully in the next day or two. All right, let me scroll through some of the other questions here. So here's a question: how is employee defined to determine the number of employees for formula retail? It actually pulls it from our minimum wage ordinance, so it's defined the same as in minimum wage, except that minimum wage says that the person has to work 2 hours in a given week to be covered by the law. So this is more expansive than that. It says if someone is scheduled for an on-call shift for at least 2 hours, then that person would also be covered. So they don't necessarily have to, in that situation, work the 2 hours, but if they're scheduled for the 2 hours, then they would be covered as well. Can we get a copy of the presentation? Yes, we will email out the slides, and we'll also post, as I said, the recording this presentation to our trainings page on our website. All right. Sorry, while I just scroll through the questions here. There's a question when I showed the planning department's webpage defining formula retail. One of the categories, I guess, was restaurant limited. Why is it limited? I think that refers to limited service. That has not come up in our enforcement actions. And ultimately, that'd be a question for the planning department, but that's my best guess on what that is. All right, still looking at some other questions. Questions about a log. I'm not totally sure what that means, but just to reiterate a point that Lucia made, which is that any schedule change, whether it's requested by the employee, whether it's something the employer does, should be documented. That's for employers the best way to show compliance, and that's what we're going to ask for as an office. If we get a complaint and approach an employer, we're going to be looking for documentation of all the requirements under the law. So that's true of all of our laws. The best thing to do is to make sure that you're documenting as much as possible. All right, still looking at some other questions here. Hang on one second. Does the law cover non-sale employees? So any employee is covered under the law of a formula retail employer. And then as Lucia said, also the contracted security guards and janitorial is covered as well. Okay, let me look at some further questions. We have a few more here. Our team members have a set schedule which is given to them upon hire. Do we still need to post a schedule every 2 weeks? Assuming there haven't been any schedule changes to remain in compliance. That's a best practice for sure. From an employer standpoint, that's the best way to protect yourself. If we got a complaint from an employee that their schedule was being changed, we would ask for copies of the schedules. And if they were not shown to be posted every 2 weeks, that would be a violation. So what I'll say generally is that we're complaint-based, but I do advise to stick to the letter of the law because we are going to ask for documentation. Let's see, there's a question when I said how many active cases. So there's a question about the timeline. The initial cases, as kind of happens, especially with a complicated law, took a little while. The 3 settlements have been within the last, I would say, 10 months approximately. So we're now starting to really move through the cases. It took a little while to get the rules in place and get everything set up and make sure that our processes were in order. So yeah, we're starting to move on them. We're starting to settle them. Repeat the number of investigations. I believe the active right now is 9 with 3 settlements. Cases generally were around the 2 weeks notice, the offering of work to part-time employees, and then the predictability pay. Those are the 3 areas so far. Let's see, what is acceptable documentation for employee requests to change schedule? So it should be in writing. At least the employer response should be in writing, and then you would just keep that on file. That would be acceptable documentation. Do your FRERO investigators or investigations also involve investigation of allegations under other ordinances? Sure. So anytime under any of our laws that we begin investigation, then we will check to see if other laws have been violated as well. And then a similar question, are the investigations company-wide? The answer is yes, although I will say that to date we've been going store location by store location, and we have found that for some employers, compliance really depends on the manager of that particular store. So that's a call for folks to make sure, if you're an employer on this, that you are training all of your managers. And we had a case where one manager was compliant, the manager left, and the new manager had not been properly trained, and then that became an issue. So it's really important for employers to make sure that the managers at all their locations are trained, and that if there's any turnover, that the new folks are trained as well in this law. And again, we're always happy to answer questions, and we have our community partners who are happy to do trainings as well. Here's a question, would online posting of available shifts be sufficient to demonstrate hours were offered to part-time employees? There is language in the law that allows for electronic posting. We would need to know that employees had access to it, and that was something that was utilized by employees on a regular basis. So that is acceptable with that caveat right there. So as of now, that's our questions. There's a couple I did not answer. We'll follow up with folks individually. If I did not answer your question, maybe just give another few seconds to see if there's any other final questions before we sign off. And again, not signing off forever. Feel free to contact us anytime. We have hotlines for all of our laws that are staffed by folks who can speak English. We have hotlines also in Spanish, Cantonese and Mandarin, Filipino. So we definitely want to make ourselves as accessible as possible. We have an email line as well. And our goal is always to get back to you as soon as possible and certainly within 24 hours. So do feel free to reach out. All right, I'm not seeing any other questions. So with that, I want to thank Lucia, and I want to thank everyone who participated. Again, if we've not answered your question here, we'll follow up with you after in the next couple of days. And yeah, really appreciate you taking the time. It's important to know what the laws require that OLSC administers and enforces, and we want to make sure that you know on the front end what your obligations are. So thanks so much for participating. And I will end the webinar. Lucia, again, thanks to you. And everyone, again, please stay in touch. Take care.
Thank you.